Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case Bruton versus United States. This case started in the Supreme Court of the United States in 1968. Let's go ahead and jump into the facts of the case. Mr. Bruton and Mr. Evans, two men, they were charged jointly by the United States government for armed robbery of a postal office. So this is a joint trial. Mr. Bruton and Mr. Evans are being tried in the same courtroom for their guilt of this crime. During the trial, the prosecutor calls a postal inspector. This postal inspector gets up and testifies that Mr. Evans told him that Mr. Evans and another man helped him rob this postal office. Essentially, he confesses to the postal inspector. So the prosecutor calls the postal inspector. Postal inspector says this. Now, this is hearsay, obviously, but it's admissible underneath a hearsay exception because the declarant, Mr. Evans, is unavailable because he's invoked his Fifth Amendment rights, and this statement is against his interests. It's a confession. It's against his interests. We believe that these statements are reliable, so we've crafted a hearsay exception for these statements. So the statement gets into evidence. Now, this statement is not admissible, however, against Mr. Bruton. Mr. Bruton didn't make this statement. So under the hearsay exception, it doesn't come in when it relates to him. So the judge gives the jury a limiting instruction. The judge says, jury, you can consider this testimony by the postal inspector where Mr. Evans confessed to the postal inspector only for Mr. Evans' guilt. You can't consider it for Mr. Bruton's guilt. Even though Mr. Evans said he was robbing this postal office with another man, and that other man is probably sitting right here in the courtroom, is going to be your obvious inference, you can't consider that. The limiting instruction says just for Mr. Evans' guilt. Well, ultimately, surprise, surprise, the jury convicts both of them for armed robbery of a postal service. Now, Mr. Bruton appeals. Mr. Bruton says that his Sixth Amendment rights have been violated when this testimony was introduced and a limiting instruction was given. His argument, chiefly, is that the limiting instruction was not enough to basically cure the violation of the Sixth Amendment. Now, what's the violation of the Sixth Amendment? The Sixth Amendment, in all criminal prosecutions, gives the defendant to confront the witnesses that come against him. So here, that witness, now it seems confusing because you think the witness is the postal inspector, but because it's a hearsay exception, the real witness is Mr. Evans in his confession. But Mr. Bruton can't cross-examine Mr. Evans because Mr. Evans is a defendant. Mr. Evans has Fifth Amendment rights, and he's not going to get up on the stand and incriminate himself, essentially. So because Mr. Evans the person who made that joint confession where he implicated Mr. Bruton, wouldn't get on the stand, Mr. Bruton's arguing that his Sixth Amendment rights to cross-examine those witnesses that make statements against him were violated. The court finds this argument compelling, and they say that the limiting instruction was not enough to cure the violation of the Sixth Amendment. This limiting instruction, basically, you're telling the jury they can't consider this evidence for Mr. Bruton's conviction, but it's very obvious that the jury's going to have a really tough time doing that. When you tell the jury to think of a pink elephant, they're probably going to think of it. When you put that piece of evidence into the courtroom, it would be naive to think that the jury isn't going to do something with it and look for, well, who might be the other robber? Oh, there's another guy sitting in the courtroom. It's probably him, right? Justice Jackson says that it would be naive to think that the jury wouldn't make this inference. And all good lawyers know that, and that's why they're going to try and get it in, right? Because they know that the jury is going to make that inference even over the top of the limiting instruction. So the court overrules a prior case which said that limiting instructions were enough to cure these facial violations of the Sixth Amendment, but the court here says, no, it's not enough. We're going to overrule that old decision. The liberty interests at stake that are protected by the Sixth Amendment are more important than the efficiency that comes with a joint trial. They point to the ability of courts to sever trials under the federal rules of criminal procedure, saying that, when there's prejudice, you can sever trials. And the advisory notes say this is the type of scenario where there would be prejudice, is a joint confession where the defendant won't get up and testify. There's a dissent by Justice White where he's basically saying Yeah, limiting instructions, they're enough. We can tell people what to think. The jury, give them a little bit more credit. They're able to delineate pieces of evidence and focus on that evidence for one defendant, but not for the other. The jury is not this, like, they're not putty. They can think for themselves. Give them a little bit of credit. His big argument is this is really just an efficiency argument, saying joint trials serve efficiency interests. We need to make sure that the federal courts are efficient. We've used limiting instructions in many other cases. Why is that not enough here? And I think the majority would come back and say it's not enough here because there's this thing in the Constitution called the Confrontation Clause. It's enshrined. It's a constitutional right. And so here, we're going to treat a limiting instruction a little bit differently than we would in other scenarios where limiting instruction is just curing a violation of the rules of evidence rather than a violation of the Sixth Amendment. So prosecutor, if there's a joint confession and a defendant isn't going to testify, meaning they'll invoke their Fifth Amendment rights, then the prosecutor has three options. The first would be to just not use the confession. That doesn't seem all that likely. A confession's a very important piece of evidence. The second would be to redact the confession. You have to do this in a very careful way to make sure that the other defendant is not implicated in any way, shape, or form, and that there's no reasonable ability of the jury to really read into it. It's going to be really tough to do in some instances. And so then the third option, which is going to be the most common, is just to sever the trials under the federal rules of criminal procedure so that we can cure the prejudice that might be done to one defendant if this were introduced. And so that's basically where the analysis is going to go for a prosecutor is either you're going to charge them together and sever or just charge them separately if you have this piece of evidence. Because that the Sixth Amendment Confrontation Clause is going to make it tricky to convict and get that conviction upheld if you introduce this confession that implicates the other defendant. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. I hope you have a nice rest of your day. Bye-bye.